Hello, welcome back to class. And today we'll be talking about business disputes, insolvency, and liquidation. And what we'll be discussing a major on exploring the legal framework governing how business resolve disputes, address insolvency, and manage liquidation process. And this area are very, very important for corporate accountability, protecting stakeholders, and ensuring continuity or orderly market exits. What do we understand by business disputes? This is conflict between parties in commercial relationship involving contracts, partnership, or intellectual property. And prompt resolution is key to maintaining operation and reputation. As per insolvency, this is a legal state where a company cannot meet financial obligations or its liability exceed assets. And it often triggers legal proceeding for rescue or winding up. And liquidation is the formal legal process of ending a company's operation involving asset sales, debt settlements, and distribution to shareholders, and it can be voluntary or compulsory. What are the mechanism of dispute resolution? And in case there are disputes or an organization or a company is experiencing a form of conflict, what are the necessary mechanism that should be put in place? The first is the alternative dispute resolution, which is informal method like negotiation, mediation, and conciliation. And faster it's actually faster, it is less expensive and more flexible than litigation and ideal for preserving business relationship. So it actually allows for negotiation, mediation, and also conciliation. And for arbitration, it's a formal process outside courts where parties submit disputes to neutral arbitrators, and these decisions are usually binding, favored for confidentiality and international enforceability. And for litigation, it is a traditional court-based dispute resolution involving formal claims and judicial determination. And it is structured and enforceable, but often time-consuming, expensive, and public. What are the causes of insolvency? Company insolvency can stem from, um, it can actually stem from internal mismanagement and external pressure. Understanding these causes helps businesses prepare for and manage financial obligations with legal boundaries. And the causes of this are over leveraging, which is excessive debt, poor cash flow management, sustained operational losses, inadequate pricing strategies, market downturn, inflation and currency depreciation, supply chain disruption, regulator or legal changes, mismanagement and fraud, and lastly, the failure and to adapt to competition. And what are the processes that a company can use in insolvency? The first can be financial assessment and declaration, where directors or creditors recognize inability to pay debts, and it involves reviewing records and consulting experts. Also, the next is the filing for insolvency, which is a formal legal proceeding initiated by voluntary complaint filing or compulsory creditor petition. And also, we have the appointment of practitioner, which is a licensed insolvency practitioner that takes control, securing assets and investigating affairs. The next is the operation and asset management, which is company may cease or continue operation, and assets are sold to pay creditor. Also, the corporate rescue and reorganization, where the procedures like Chapter 11 of USA or administration and that of UK or Nigeria aims to restore financial health. And lastly is conclusion and dissolution, which is company is restored if reorganization succeed or it winds up if and dissolve if it is not actually reorganized. There are laws that deals with bankruptcy, and this is actually a comparative bankruptcy law. And for USA, it's actually the Chapter 11, and for UK, it is the Insolvency Act of 1986, and for Nigeria, it is a KAMA 2020. We're talking about modernized framework with CVAs and administration aligning with global best practices, and this promotes business rescue and creditors' rights. We have who we call the liquidators and the receiver. And what are their roles? A liquidator is appointed to wind up the affairs of an insolvent company, and he has the role to manage the orderly dissolution of the company, realize its assets, and distribute the proceeds to creditors and shareholders in accordance with applicable laws. And their responsibility, just like it has been said, is asset collection, creditors management, distribution of proceeds, investigation of financial affairs, and act impartially for all creditors. And for the role of receivers, a receiver is usually appointed by a secured creditor, such as a bank, under the term of a debenture or loan agreement, typically when the company defaults on its debt obligation. A receiver has the responsibility to take control of pledged assets, to sell them to recover the loan, and may temporarily operate the business, and also has the responsibility or role of to act primarily for the appointing secured creditors. The legal consequences of corporate restructuring. Insolvency triggers far-reaching legal consequences, including automatic moratorium and potential personal liabilities for directors. And corporate restructuring offers a pathway to survival, involving financial reorganization and operational overhaul to restore viability as such. And when we talk about moratorium, it's actually automatic stay. It's automatic stays prevents uh, creditors from individual enforcement actions once insolvency proceeding begins. For directors' liability, directors may lose control and face personal liability for wrongful or fraudulent trading. And lastly, for restructuring pathway, legal framework like that of the Chapter 11 of US and administration for the country supports debt refinancing and operational changes. And in conclusion, it is very critical to know that the legal framework governing business disputes, insolvency, and liquidation, which are essential for maintaining corporate accountability and economic stability. So, having the understanding of this that we've discussed as it pertains to dispute resolution, the mechanism, and so other things that are discussed, having the understanding of these legal processes is crucial for business leaders, legal practitioners, and stakeholders to navigate financial distress and disputes effectively, ensuring compliance and minimizing economic disruption. We will be going to the last module in the next video, so I want you to check through it.